Hello guys, welcome back to our channel Legal Nexus. In this video, we simplify the legal concept of nuisance, a major topic in tort law. Nuisance generally means to do hurt or to annoy. Nuisance is defined as anything done to hurt or annoyance of the land tenants of another and not amounting the trespass. Essentials of nuisance: unlawful interference with the person's use of land and unlawful interference with enjoyment of land, enjoyment of some right over land or in connection with it. Types of nuisance: nuisance can be public or general nuisance and private or common nuisance. Public nuisance is an act or omission of an act causing common injuries, danger, or annoyance to the public. It may be also to do dwelling property. The public nuisance may also endanger the safety, comfort, and health of public. In general, public nuisance is also crime and so punished as an offense. Generally, a private individual cannot sue for public nuisance, but if the following three conditions are satisfied, then the private individual can maintain a suit for public nuisance. The plaintiff must have suffered special damage. The injury or loss to the plaintiff must be direct and natural. The injury or loss to the plaintiff must be substantial, not negligible. Harold versus Wagner is an important case related to this statement. A 4-year-old child, while climbing a defective fence in a highway, fell down and injured. The court held that the defendant was liable to pay compensation because it was a public nuisance. Remedies for public nuisance: a civil action can be maintained by collectors or advocate general or two or more persons getting his sanction. Criminal action can also be taken under the IPC and CRPC as public nuisance is offense. If any person suffered special damage, civil right of action is available for him. For example, if a pit is dug in middle of public road, it may cause public nuisance, but no private individual can sue for public nuisance. However, if a person is injured by falling into it, he can sue for tort. Private nuisance. The term private nuisance is the unauthorized use of man's own property causing damage to the property of another. It is also the unauthorized interference with the property right of another. It does not amount to trespass. Obstruction of light, air, wrongful escape of gases, smoke, etc. are example of private nuisance. Type of private nuisance. Private nuisance is divided into two types: nuisance of property and nuisance to physical comfort. Nuisance to property. Some damages or loss of the property must be proved for an action in tort of nuisance. Nuisance to physical comfort means if the defendant uses his land as to interfere with the physical comfort of other person, then he commits private nuisance. Remedies available for private nuisance are: there are three remedies available: abatement, damage, and injunction. Abatement: it is the removal of nuisance by the injured party. The removal must be done peacefully without any injury. For example, cutting the overhanging branches of mango trees which protrude into one's garden. Second remedy is damages. If the injured party has suffered substantial damage, then he can also claim compensation. The course of action of nuisance arises day to day, and hence it is termed de die indium. Injunction. If the compensation is not an adequate remedy, then the injured party can claim injunction. Injunction is an order of court to the defendant to do or not to do a specific act. Defenses available for nuisance. There are a number of defenses which have been pleaded in an action for nuisance, but the court recognized some of the defense as valid defense and others have been rejected. Valid defenses: easement by prescription. If a person has continuously engaged in an activity on the land of another person for 20 years or more, he acquires a legal right by prescription to continue the act there in future also. A right to commit a private nuisance may be acquired as an easement if such nuisance has been peacefully and openly enjoyed as an easement and as of right without interruption and for 20 years. 233A. If the nuisance has been authorized by the servant landowner for period of 20 years, the nuisance become legalized ab initio. The period of 20 years cannot be commenced to run until the act complained of begins to be a nuisance. Statutory authority. An act done under the authority of statute is completely different. If nuisance is an incident authorized by a statute, then there is no liability. A railway company authorized to run railway trains on a track is not liable if, in spite of due care, the spark from the engine set fire to nearby property. Invalid defense. Nuisance due to act of other. The act of two or more persons acting independently of each other may cause nuisance. An action can be brought against any one of them, and it is no defense that the act of the defendant alone would not be nuisance. Public good. Even if an act is beneficial to the public in general, but if the same act is nuisance to a particular plaintiff, there is actionable. Reasonable care. Use of reasonable care to prevent nuisances. Defense. To sum up, nuisance is all about protecting people's right to enjoy their property without unreasonable interference, whether it is loud factory pollution or a public obstruction. Nuisance law helps maintain balance between individual right and public welfare. Understanding the difference between public and private nuisance along with key elements and remedies is essential for any law student or legal enthusiast. Thanks for watching this video. If you found this video helpful, don't forget to like, share and subscribe for more legal content.